The gavel strikes once, twice. The sound echoes through Franklin County Courthouse on this cold October morning, each bang like a nail being driven into a coffin. Judge Bernard Holloway peers down from his elevated bench, his thin lips curved into something that might generously be called a smile, but looks more like a predator sizing up prey. The woman sitting at the defendant's table doesn't flinch. Brooke Washington, 35 years old, with calloused hands folded neatly in front of her, stares straight ahead. Her navy blue dress is simple, pressed, respectful, the kind of outfit someone wears when they still believe the system might work in their favor. "You think you're somebody special with that little beauty shop?" The judge's voice drips with contempt, each word carefully chosen to cut. "Let me tell you something, sweetheart. You're nothing but ghetto trash playing pretend businesswoman." The gallery behind Brooke shifts uncomfortably. A few people look down at their hands. Others lean forward, sensing blood in the water. Brooke doesn't turn around, doesn't react. Her breathing remains steady, controlled. "Your Honor, with respect, I'm here because someone filed false charges against my salon." Holloway's laugh is sharp, theatrical. "False charges? Ha! The evidence shows money laundering, drug storage. Your little curl shop is a front operation and we all know it." In her purse, Brooke's fingers brush against a small memory card, smaller than her thumbnail but containing nearly 40 minutes of recorded conversation. Yesterday at 3:17 p.m., the voice on that recording belongs to the man currently sitting 20 feet above her, wearing black robes like armor. "Judge," Brooke's voice is soft, almost conversational. "I have a question about the timeline of events." "You don't get to ask questions here. This isn't your neighborhood barbershop." Brooke reaches into her purse with deliberate slowness. Her phone emerges, screen facing up. The courtroom clerk frowns. The bailiff takes half a step forward. Brooke's thumb hovers over an app icon. "With your permission, Your Honor, I'd like to read something into the record." Holloway leans back, enjoying himself now. "Oh, this should be good. What are you going to read? Your eviction notice?" Brooke's thumb touches the screen. A soft click, then another. The app opens, displaying an audio file marked with yesterday's date and a timestamp, 15:17 hours. "Actually," Brooke says, her voice carrying clearly through the suddenly quiet courtroom, "I was going to read back something you said yesterday afternoon." The silence that follows is different, heavier. Judge Holloway's confident smirk wavers for just a moment. The lock clicks twice, then silence. 6 hours earlier, Brooke Washington unlocked the glass door of Washington Curls and Company as the sun painted Franklin County's downtown streets in shades of amber and shadow. 6 a.m. sharp, same as every morning for the past 8 years. Her movements were precise, economical. Flip the lights, check the appointment book. Arrange tools in perfect parallel lines. Each curling iron had its place. Each bottle of product aligned to the quarter inch. The kind of habits that spoke to discipline most people never noticed. Mrs. Vivian Cross arrived at 6:30, punctual as always. 72 years old with silver hair that held memories of better times and worse ones. She settled into Brooke's chair with a soft sigh. "That bank again yesterday," Mrs. Cross began, her voice carrying the particular weariness of someone who'd fought the same battles too many times. "Told me their computer system was down when I tried to make a withdrawal. 3rd time this month. Funny how it only happens to certain customers." Brooke worked coconut oil through Mrs. Cross's hair with gentle, methodical strokes. She listened without comment, but her dark eyes caught every detail in the mirror's reflection. The slight tremor in the older woman's hands. The way she pressed her lips together when mentioning amounts. $800 for her granddaughter's school clothes, denied without explanation. "Did they give you any paperwork? Receipt showing the attempted transaction?" Said the system couldn't print anything either. Brooke's hands never paused, but something shifted behind her eyes. A sharpness that belonged more in a boardroom than a beauty salon. She filed the information away with the precision of someone keeping score. At 7:15, Officer Blake pushed through the front door, his uniform wrinkled from a night shift that had run long. Brooke had been cutting his hair for 3 years. He was one of the good ones, the kind of cop who still remembered that badge meant service, not power. "The usual?" Brooke asked, already reaching for her clippers. "Yeah, but keep it quick today. Captain's got us all wound up about some new directive from downtown." Blake settled into the chair, closing his eyes as Brooke worked. "Pressure from above, you know. Word is we're supposed to be more aggressive about certain types of compliance issues." Brooke's hand stilled for just a moment. "What kind of compliance issues?" "Business licenses, code violations, that sort of thing." Blake's voice carried an edge of discomfort. "Especially in this district. Between you and me, it feels targeted." The clippers resumed their steady buzz. Brooke said nothing, but she was listening with the intensity of someone reading between very carefully drawn lines. In her experience, when police started getting pressure from above about compliance, It usually meant someone with money wanted something moved. That sounds procedurally irregular, she said finally. Blake opened one eye. Irregular how? Compliance enforcement is supposed to be complaint-driven or routine inspection. Random sweeps violate due process unless there's demonstrated probable cause. The officer sat up a little straighter. You know about due process? Brooke smiled, the expression warm but revealing nothing. I listen to my customers, pick things up. At 8:45, court reporter Jade Mills stopped by for her weekly wash and set, 28 years old, ambitious, and increasingly troubled by what she was seeing in Judge Holloway's courtroom. Brooke shampooed her hair while Jade stared at the ceiling, working through problems she couldn't quite articulate. He's been giving me weird instructions lately, Jade said finally, about what to include in official transcripts. Asked me to summarize rather than quote directly during a sentencing hearing last week. Brooke's fingers worked through Jade's scalp, applying just enough pressure to be soothing. Is that normal procedure? Not even close. Court reporters are supposed to create verbatim records. That's literally our job. Jade sat up as Brooke wrapped a towel around her head. But when I questioned it, he said I was overstepping my role. Did you document his instruction? Jade paused. No, should I have? Brooke's reflection met Jade's eyes in the mirror. In your position, I'd want everything documented, for my own protection. Through the salon's front window, Brooke watched a black town car slide past. Shaw Morrison sat in the passenger seat, phone pressed to his ear, eyes scanning the storefronts like a general surveying territory he intended to conquer. His gaze lingered on Washington Curls and Company, calculating square footage and profit margins. Brooke memorized the license plate without appearing to look. She'd been tracking Shaw's visits to the neighborhood for 6 weeks. Always the same route. Always the same calculating stare. Always on Wednesdays, when city planning meetings happened 3 blocks away. Mrs. Davis from the flower shop next door knocked on the window at 10:30, holding an official-looking envelope. Brooke stepped outside, noting how Mrs. Davis's hands shook as she passed over the papers. Code violation notice, Mrs. Davis explained. Came certified mail this morning. Says my sidewalk display violates Municipal Ordinance 14-22. Brooke scanned the document. Professional letterhead, official seals, proper legal formatting. But something nagged at her about the citation numbers. When did you put the flower displays outside? Been there for 12 years. Same spot, same setup. And Ordinance 14-22 was enacted when? Mrs. Davis blinked. How would I know that? Brooke disappeared into her salon for 30 seconds and returned with her laptop. Her fingers moved across the keyboard with surprising speed, navigating municipal databases with the efficiency of someone who'd done this before. Ordinance 14-22 was enacted 6 weeks ago, Brooke said quietly. But it wasn't published in the public notice section of the Franklin Gazette until last week. You can't be cited for violating a law you had no reasonable way of knowing existed. Mrs. Davis stared at her. How did you find that so fast? Brooke's smile was gentle, deflecting. Like I said, I listen to my customers. You pick things up. If you're as stunned as I am by what just happened, you need to hear what comes next. This story gets even more unbelievable. Make sure to hit that subscribe button because you won't want to miss how Brooke's simple salon became the center of the biggest corruption scandal Franklin County has ever seen. Trust me, the next revelation will blow your mind. At 11:15, Shaw Morrison himself walked past the salon, not in his town car this time, but on foot, moving with the casual confidence of someone who owned everything he surveyed. He paused directly in front of Brooke's window, pulled out his phone, and made a call while staring through the glass. Brooke continued working on her client's hair, but her peripheral vision tracked every gesture. Shaw's mouth moved with animated enthusiasm. He gestured toward the building, made notes on his phone, took 3 photos of the storefront. When he finished the call, he walked directly to the planning office 3 blocks away. Brooke excused herself for a moment, stepped into her back office, and opened a composition notebook. Page 47 contained detailed logs of Shaw's visits, with dates, times, duration of stay, and apparent purpose. Today's entry would be brief but significant. First time approaching the building directly. First time photographing the property. At 12:30, Devin Holloway, the judge's nephew and a city planning clerk, appeared at Brooke's door. 25 years old, soft around the middle, with the particular arrogance of someone who'd never earned anything but expected everything. Ms. Washington, I need to speak with you about your business license. Brooke wiped her hands on a towel before responding. What about it? There's been a complaint. Anonymous tip about improper use of commercial space. What kind of improper use? Devin shifted his weight, clearly uncomfortable with direct questions. Look, this is just preliminary. but we need to schedule an inspection. Review your permits, make sure everything's up to code. Brooke pulled her business license from a frame on the wall and handed it to Devin. Current through next March. All taxes paid. Health department certification prominently displayed. Fire department clearance updated 6 months ago. This all looks... Devin scanned the documents, searching for problems that didn't exist. Look, there's still the matter of the anonymous complaint. What was the nature of the complaint? I can't reveal specifics. Brooke's voice remained level, professional. Under the municipal code, property owners have the right to review complaint documentation before enforcement action. Would you like me to file a formal request for records? Devin's face flushed. That won't be necessary. We'll just schedule the inspection and see what we find. I'll need that request in writing with proper legal justification cited. You'll need what? Brooke's smile was patient, the kind reserved for children who didn't understand the rules of games they'd insisted on playing. Written notice with statutory authority for the inspection. Due process requirements under the Fourth Amendment. Devin left without scheduling anything. At 2 p.m., Inspector Kane arrived unannounced. 40-something, tired around the eyes, carrying a clipboard thick with forms that looked suspiciously pre-filled. He introduced himself with the weary professionalism of someone going through motions he'd rather avoid. Routine inspection, he explained, though Brooke had received no notice and routine inspections typically happened annually. Won't take long. Brooke led him through the salon, pointing out recent upgrades to electrical systems, new plumbing installed last spring, fire extinguisher inspections current through next year. Kane made notes, but his attention seemed focused on finding violations rather than confirming compliance. This drain cover seems loose, Kane said, crouching next to a sink that had passed inspection 3 months earlier. Brooke knelt beside him. The drain cover was perfectly secure. Would you like me to demonstrate the installation? Kane straightened quickly. That won't be necessary, just make sure you keep an eye on things like that. He left after 20 minutes, clipboard still thick with unused violation forms. Brooke locked the door behind him and returned to her composition notebook. Page 51 now contained detailed documentation of the inspection, including Kane's failure to find actionable violations despite clearly searching for them. She photographed each page with her phone and uploaded the images to a cloud storage account that automatically backed up to 3 separate servers. The afternoon brought regular customers with familiar stories. Sandra from the tax office mentioned unusual pressure to reassess property values in the downtown district. Mark from the post office talked about delivery delays for certain addresses, all of them businesses owned by minorities. Lisa from the court clerk's office whispered about Judge Holloway's increasingly irregular scheduling practices. Brooke listened to everything, remembered everything, documented everything. Speaking of evidence and documentation, if you're concerned about protecting yourself in situations like Brooke faced, you need to know about Legal Shield. For less than $1 a day, you get access to experienced attorneys who can review documents, write letters, and provide legal consultation. Don't wait until you're in court like Brooke. Protect yourself now. Visit LegalShield.com and use code JUSTICE for your first month free. Because everyone deserves legal protection regardless of their zip code. By 5 p.m., as Brooke swept hair from the floor and sanitized her tools, with military precision, a pattern had emerged. Anonymous complaints, surprise inspections, pressure on city employees, mysterious policy changes that affected specific types of businesses in specific neighborhoods. Someone was orchestrating a campaign. Someone with enough influence to manipulate multiple city departments. Someone who wanted certain properties available for development and didn't care what methods were necessary to make that happen. Brooke finished closing the salon and sat in her car for 10 minutes, engine off, watching the building across the street. Shaw Morrison's town car was parked there again, passenger window down. Phone conversations animated and frequent. She started her Honda Civic and drove home, taking a route that allowed her to pass the planning office. Shaw's Mercedes was in the parking lot next to Judge Holloway's Cadillac. 2 men having dinner at 7 p.m. on a Wednesday. Nothing illegal about that, but Brooke photographed the license plates anyway. Brooke's phone buzzed at 5:47 a.m., 17 minutes before her usual alarm. Unknown number. She let it go to voicemail while she dressed in the dim pre-dawn light of her apartment. The message was brief, automated. This is Franklin County Police Department. Please call regarding urgent matter involving your business. She called back at 6:15 after coffee, after checking local news for overnight incidents. Detective Warren answered on the second ring. Ms. Washington, we need you to come down to the station. There's been a complaint about your salon. What kind of complaint? Better discussed in person. Can you come in this morning? Brooke checked her appointment book. Mrs. Cross at 7:30, 3 regulars between 9 and noon. I have customers scheduled. Can we handle this over the phone? I'm afraid not. This is serious, Ms. Washington. Something in his tone made Brooks' chest tighten. Not angry, not aggressive, just careful. The way people sounded when they were following a script they didn't particularly like. I'll be there in 30 minutes. Brooke arrived at the Franklin County Police Station at 6:55 a.m. to find Detective Warren waiting in the lobby with paperwork that looked far too organized for a complaint received overnight. Search warrant, sworn affidavit, evidence bags already labeled. Ms. Washington, I have a warrant to search Washington Curls and Company based on reliable information regarding potential money laundering activities. Brooke read the warrant twice, signed by Judge Holloway at 11:47 p.m. the previous night, less than 8 hours ago. The supporting affidavit mentioned an anonymous informant who claimed to have witnessed suspicious cash transactions and possible narcotics storage. Detective Warren, may I ask about the timeline here? This warrant was issued at nearly midnight on a Wednesday. Judge Holloway was available for emergency proceedings. Brooks' legal knowledge, accumulated through years of listening to courthouse employees discuss procedure, kicked into focus. Emergency warrants require immediate threat to public safety or risk of evidence destruction. What emergency circumstance justified midnight issuance? Warren shifted uncomfortably. The informant indicated time-sensitive situation. And the informant's reliability has been established how? Ms. Washington, I'm not required to discuss investigative details with you. But Brooke was already noting discrepancies. Emergency warrants required specific danger articulation. Midnight judicial availability was reserved for violent crimes or flight risks. Nothing in the affidavit suggested either circumstance. I'd like my attorney present. That's your right, but we're executing this warrant with or without legal representation. 20 minutes later, Brooke stood outside her salon watching 6 police officers conduct what appeared to be a carefully orchestrated performance. Detective Warren led the team with professional efficiency, but his discomfort was visible to anyone paying attention. 2 officers examined the appointment book while another photographed client files that contained nothing more sensitive than preferred hair products. Officer Blake emerged from the back room carrying an evidence bag containing a small plastic packet. Brooke's blood went cold. Found this in the old hairdryer, Blake announced. Back corner. Brooke stared at the evidence bag. The hairdryer in question was a 1970s Belvedere crown unit that hadn't worked in 6 years. She kept it for sentimental reasons. It had belonged to her mother, but she'd never used it for storage, and certainly never for anything illegal. Detective Warren, I'd like to request documentation of chain of custody for that evidence. Warren looked surprised. Chain of custody? Yes. Florida Statute 933.07 requires documentation of evidence handling from discovery through analysis. I'd like the incident report to reflect that the substance was photographed in situ before removal, that multiple officers witnessed its discovery, and that proper evidence sealing procedures were followed. Blake and 2 other officers exchanged glances. Warren pulled out his notebook and began writing with more care than he'd shown previously. Brooke continued, her voice steady despite the situation spiraling beyond her control. I'd also like the record to show that the hairdryer in question has been non-functional for approximately 6 years, as confirmed by repair receipts I can provide, and that I had no knowledge of any foreign substances being placed inside it. Ma'am, Warren said quietly, you might want to save this for your lawyer. I'm not making statements about guilt or innocence. I'm requesting proper documentation of evidence discovery to protect the integrity of your investigation. Shaw Morrison's black town car pulled up across the street just as Brooke was being placed in handcuffs. He didn't get out, but Brooke could see him on the phone, watching the proceedings with obvious satisfaction. She memorized the time, 8:37 a.m., and noted that Shaw's presence at the exact moment of her arrest suggested prior knowledge of police action. At the station, Brooke was processed with unusual efficiency. Booking photos, fingerprints, personal property inventory. The desk sergeant, a 20-year veteran named Collins, handled everything by the book, but with obvious reluctance. Ms. Washington, I'm required to inform you that Judge Holloway has set an emergency bond hearing for 3 p.m. today. Brooke looked up from the paperwork she was signing. Emergency bond hearing? For alleged money laundering? Judge's discretion. But Brooke knew the system well enough to recognize more irregularities. Bond hearings typically took 3 to 5 days to schedule. Emergency hearings were reserved for violent crimes where public safety was at immediate risk. Money laundering allegations, even if true, didn't require emergency judicial intervention. Sergeant Collins, I'd like to request a copy of the arrest report and warrant application. Those will be available through discovery once you're represented by counsel. Actually, under Florida Statute 914.04, arrest reports become public record within 72 hours unless sealed by court order. I'm requesting immediate access as the arrested party. Collins paused, clearly unfamiliar with civilians who understood legal procedure. I'll have to check with the detective. Brooke spent 4 hours in holding, sharing space with 2 women arrested for shoplifting and 1 picked up on outstanding traffic warrants. She used the time to mentally review everything she'd observed, organizing details with the precision of someone accustomed to processing complex information. The timing was too convenient. Shaw Morrison's presence too perfectly orchestrated. Judge Holloway's midnight availability too coincidental. Someone had planned this operation carefully, but they'd underestimated Brooke's knowledge of legal procedure and overestimated her willingness to quietly accept injustice. At noon, a public defender named Aaron Ross arrived, 35 years old, carrying a briefcase held together with electrical tape, and managing a caseload that would have broken most attorneys. He had exactly 18 minutes to review Brooke's case before bond hearing. Ms. Washington, I've looked at the charges: money laundering, possession with intent to distribute. Given your clean record, I think we can argue for reasonable bond. Mr. Ross, have you reviewed the warrant application? Briefly, Brooke leaned forward. The warrant was issued at 11:47 p.m. on Wednesday for execution Thursday morning. Emergency procedures were used without emergency justification. The supporting affidavit lacks specific probable cause articulation required under Florida law. Ross looked up from his notes. You seem to know a lot about legal procedure. I listen to my customers. They talk about their work. What kind of customers? Brooke smiled. Court employees, police officers, city workers, small community, Mr. Ross. Everyone gets their hair cut somewhere. At 3 p.m. sharp, Brooke stood before Judge Holloway in Franklin County Court. The gallery was half full, unusual for a bond hearing. Shaw Morrison sat in the back row. Devin Holloway occupied a front seat. 3 people Brooke didn't recognize took notes with the intensity of journalists or private investigators. Judge Holloway reviewed the case file with theatrical deliberation. Ms. Washington, you're charged with serious felonies involving money laundering and controlled substances. These charges suggest a sophisticated criminal enterprise operating under the guise of legitimate business. Brooke's attorney stood. Your Honor, Ms. Washington has no criminal record. She's operated a successful business in this community for 8 years. She has strong ties to the area and presents no flight risk. Mr. Ross, the evidence suggests otherwise. Large cash transactions, suspicious storage of contraband. This appears to be organized criminal activity. Brooke rose slowly. Your Honor, may I respectfully request clarification of the evidence? Holloway's eyes narrowed. You may not. Defendants don't question the court. I'm not questioning the court, Your Honor. I'm requesting information about evidence used to justify my detention, which is my right under the 6th Amendment. Your right is to sit quietly while your attorney represents you. Brooke remained standing. Your Honor, the warrant affidavit mentions large cash transactions, but my business operates on credit cards and checks, with all transactions documented for tax purposes. Bank records will show deposits consistent with normal salon operation. Ms. Washington, sit down. Your Honor, the warrant also alleges suspicious storage of contraband and equipment I haven't used for 6 years. Utility records will show that hairdresser hasn't been connected to electrical service since 2018. Judge Holloway's face reddened. I said sit down. Brooke's voice remained calm, respectful, but persistent. Your Honor, I'm simply requesting that evidence be examined for consistency before bond determination affects my ability to maintain employment and housing. The courtroom fell silent. Shaw Morrison leaned forward. Devin Holloway smirked. Judge Holloway gripped his gavel like a weapon. Ms. Washington, you seem to think you're smart enough to lecture this court on procedure. No, Your Honor, I just think everyone deserves equal treatment under law. Holloway's laugh was sharp, cruel. Equal treatment? You think you're equal to the people in this courtroom? Brooke's composure never wavered. I think justice should be equal, Your Honor. Justice? Holloway's voice dripped contempt. You want to talk about justice? You run a little storefront in the ghetto and think you understand how the world works? You think your beauty shop makes you somebody important? The gallery stirred. Aaron Ross half rose from his chair, sensing dangerous territory. Judge Holloway continued, his voice rising with each word. Let me tell you what you are, Ms. Washington. You're nothing but ghetto trash playing pretend businesswoman. You think you can come into my courtroom and quote law like you belong here? You think you're somebody special with that little beauty shop? Brooke stood perfectly still, absorbing every word, her dark eyes never leaving the judge's face. You're nothing, Holloway continued. Nothing but a drug dealer hiding behind hair products, and we all know it. In the gallery, Shaw Morrison smiled. Devin Holloway nodded approvingly. The unknown note-takers scribbled furiously. Brooke reached into her purse with deliberate slowness. Her phone emerged, screen facing up. She touched the screen twice, soft clicks that carried clearly through the silent courtroom. "Your Honor," Brooke said quietly, "with the court's permission, I'd like to read something into the record." Holloway leaned back, enjoying the moment. "Oh, this should be good. What are you going to read? Your eviction notice?" Brooke's thumb moved across her phone screen. An audio file appeared, marked with yesterday's date and timestamp, 15:17 hours. "Actually, Your Honor, I was going to read back something you said yesterday afternoon." The silence that followed was different, heavier. Judge Holloway's confident expression began to shift. Brooke looked up from her phone, meeting his eyes directly. "The recording where you told Shaw Morrison that my salon would be a parking lot by Tuesday." The lock clicks twice, then silence. The courtroom erupted in whispers that Judge Holloway's frantic gavel banging couldn't silence. Shaw Morrison's face went ashen as he fumbled for his phone, probably calculating how quickly he could leave the building. Devin Holloway slumped in his seat like someone had pulled his strings. The unknown note-takers wrote with frenzied intensity. "Order!" Holloway shouted, his voice cracking slightly. "I will have order in this courtroom!" Brooke remained standing, her phone still in her hand, the audio file clearly visible on the screen. She hadn't pressed play yet, hadn't needed to. The mere suggestion that such a recording existed had shifted the entire dynamic of the room. "Your Honor," Aaron Ross said, finding his voice, "if my client has evidence of judicial bias, this court should consider recusal under Rule 2.11 of the Florida Code of Judicial Conduct." Holloway's eyes darted between Brooke's phone and Shaw Morrison, who was quietly gathering his things. "Mr. Ross, your client is attempting to manipulate these proceedings with fabricated evidence." Brooke's voice cut through the tension, calm and clear. "Your Honor, I haven't presented any evidence yet. I simply mentioned the existence of a conversation. If you'd like, I can authenticate the recording according to Florida Evidence Code Section 90.951. The judge's gavel froze mid-swing. Brooke wasn't supposed to know about evidence authentication procedures. She was supposed to be an uneducated woman from the wrong side of town, easily intimidated and quickly processed through a system designed to favor people like Shaw Morrison. But Brooke Washington had spent 8 years cutting hair for courthouse employees, police officers, and city workers. She'd listened to thousands of conversations about legal procedures, constitutional rights, and bureaucratic processes. More importantly, she'd remembered everything. "This court is in recess," Holloway announced abruptly. "Bond hearing postponed pending review of circumstances." Brooke was returned to holding while Aaron Ross huddled with the prosecutor, DA Elena Ross, no relation, despite the shared surname. Elena was a career prosecutor, ambitious and generally competent, but she'd been blindsided by the rapid developments in what should have been a straightforward bond hearing. "Aaron," Elena said quietly, "what exactly does your client have?" "I don't know yet, but if she's got Holloway on tape discussing case disposition with interested parties, we've got serious problems." Elena had been practicing law for 12 years. She'd seen corruption before. Small-town politics bred it like standing water bred mosquitoes. But she'd never seen a defendant walk into court with potential evidence of judicial conspiracy. "Can you control her?" Aaron almost laughed. "Control Brooke Washington? Elena, I've known her for exactly 45 minutes, and in that time she's demonstrated better knowledge of criminal procedure than half the attorneys in this building." 3 hours later, Brooke was released on her own recognizance pending a hearing scheduled for the following week. The rapid reversal of Judge Holloway's initial position suggested panic, which suggested Brooke's implied recording was more damaging than anyone wanted to admit publicly. Brooke walked out of the courthouse to find a small crowd gathered on the steps. Word had spread through Franklin County's tight-knit community. The hairdresser who knew everyone's secrets had turned the tables on Judge Holloway himself. Mrs. Cross waited by Brooke's car, worry etched in the lines around her eyes. "Child, what have you gotten yourself into?" "I'm not sure yet," Brooke admitted, "but I think I'm about to find out just how deep this goes." That evening, Brooke sat in her apartment reviewing 8 months of notes she'd accumulated about irregularities in city operations. Patterns emerged when viewed chronologically: property assessments that coincidentally affected minority-owned businesses, code enforcement that disproportionately targeted certain neighborhoods, and judicial decisions that consistently favored development interests over individual property owners. Her phone rang at 9:37 p.m. Unknown number. "Ms. Washington, this is Agent Robert Patterson, Federal Bureau of Investigation. I believe we need to talk." I can't imagine the courage it took for Brooke to sit there, facing a corrupt judge who saw her as nothing. If this story is hitting you in the gut like it's hitting me, show some love in the comments. And please subscribe. Stories like Brooke's need to be heard. She's about to reveal something that will change everything you think you know about justice. Agent Patterson arrived at Brooks' apartment 20 minutes later, accompanied by Agent Rachel Brooks from the Civil Rights Division. They wore civilian clothes and drove an unmarked sedan, but their federal badges were unmistakable. Ms. Washington, we've been monitoring certain activities in Franklin County for approximately 8 months, Patterson explained. Your situation has come to our attention. Brooke offered coffee, which they accepted, and gestured to her small dining table. What kind of activities? Civil rights violations, systematic targeting of minority-owned businesses, potential conspiracy between elected officials and private developers. Brooke studied Agent Patterson's face. Mid-40s, African-American with the careful manner of someone accustomed to investigating corruption in small communities where everyone knew everyone else's business. How can I help? Agent Brooks leaned forward. Actually, we think you might have been helping already. Your salon serves a unique cross-section of Franklin County employees, court staff, police officers, city workers, people who talk about their jobs while getting their hair cut. People say things, Brooke acknowledged carefully. Things like judicial bias, procedural irregularities, pressure from supervisors to target specific properties or individuals. Patterson's voice was neutral, professional, the kind of things that might constitute a pattern of civil rights violations. Brooke was quiet for a long moment, weighing her options. Federal agents didn't show up at your apartment because they were fishing for information. They showed up because they already had information and needed someone to help them use it. What exactly are you asking me? We're asking if you'd be willing to cooperate with a federal investigation into corruption and civil rights violations in Franklin County, Agent Brooks said. Specifically, we're interested in any information you might have about coordination between Judge Holloway, Shaw Morrison, and other officials to manipulate legal proceedings for financial gain. Brooke thought about Mrs. Cross being denied bank withdrawals, about Officer Blake receiving pressure to target specific businesses, about Jade Mills being instructed to alter court transcripts, about dozens of customers who'd mentioned irregularities over the past 8 months. I keep detailed notes, she said finally. Customer conversations, observations, dates, and times. I've been documenting what seemed like systematic harassment of minority businesses. Patterson and Brooks exchanged glances. This was better than they'd hoped. Ms. Washington, would you be willing to wear a recording device during future conversations? Help us document ongoing criminal activity? Brooke considered the question seriously. What are the risks? Minimal, if we do this correctly. You'd continue normal business operations. If certain people approach you to discuss legal matters or attempt to pressure you, we'd have documentation. And if they discover the recording equipment? Agent Brooks's expression sobered. That's a risk we'd work to minimize. But yes, there would be personal danger if your cooperation became known. Brooke looked around her small apartment. The framed photos of her mother, the bookshelves filled with legal texts she'd acquired over years of trying to understand the system her customers navigated daily, the composition notebooks filled with 8 months of careful observations. Agent Patterson, how long have you been investigating Franklin County? Officially, 8 months. Unofficially, we've been receiving complaints for over a year. And in all that time, has anyone been prosecuted? Patterson's silence was answer enough. Brooke stood and walked to her bedroom, returning with a banker's box filled with composition notebooks, printed emails, photographs, and manila folders organized with military precision. I've been conducting my own investigation, she said, placing the box on the table. Cross-referenced customer complaints with public records, documented timeline correlations between city council meetings and subsequent enforcement actions, identified patterns of selective prosecution and biased judicial decisions. Agent Brooks opened one of the notebooks and began reading. Her eyebrows rose progressively higher as she scanned Brooks' meticulous documentation. Ms. Washington, this is comprehensive. How did you know to document all this? Brooks smiled. Agent Brooks, when you cut hair for the people who run the system, you learn how the system is supposed to work. And when you see it working differently for different people, you start taking notes. Patterson was examining photographs of Shaw Morrison's vehicle parked at various city buildings during non-business hours. How long have you been tracking Morrison's movements? 6 weeks. Ever since Mrs. Davis received that code violation notice for ordinances that didn't exist when she allegedly violated them. The federal agents spent 2 hours reviewing Brooks' evidence. Her documentation was thorough, chronological, and legally precise. She'd identified patterns that supported federal civil rights charges under multiple statutes. Ms. Washington, Patterson said finally, we'd like to offer you formal protection and compensation as a confidential informant in this investigation. Brooks shook her head. I don't want to be confidential. I'm sorry? I don't want to hide. I want Judge Holloway and Shaw Morrison to know that someone is watching. I want them to know that their actions have consequences. Agent Brooks frowned. That's much more dangerous than confidential cooperation. Maybe, but it's also more effective. Brooke opened another notebook, this one containing what appeared to be detailed psychological profiles. I've been studying these men for 8 months. Holloway is arrogant but insecure. Morrison is careful but greedy. They make mistakes when they feel pressured. You want to pressure them into making mistakes? I want to document their mistakes when they inevitably make them. Brooke closed the notebook. The question is whether the FBI wants to be in position to catch those mistakes when they happen. Over the following week, Brooke returned to normal salon operations while federal agents established surveillance on Judge Holloway and Shaw Morrison. Brooke's daily routine continued unchanged, but now her composition notebooks served dual purposes: business records and federal evidence documentation. Brooke's salon was her entire livelihood, and she nearly lost everything to false charges. That's exactly why you need Next Insurance, affordable business insurance designed for small business owners like Brooke. Whether you run a salon, restaurant, or consulting business, Next protects you from lawsuits, property damage, and liability claims. Get an instant quote at nextinsurance.com in under 60 seconds. Use code PROTECT for 10% off your first year. Don't let your American dream become vulnerable to corruption. The pressure on Brooke intensified gradually, like water slowly coming to boil. Anonymous calls to city inspectors resulted in surprise visits from health department officials, fire marshals, and building code enforcers. Each inspection found minor violations that hadn't existed during previous reviews. A hand sanitizer dispenser mounted 2 inches too low, a fire extinguisher inspection sticker that had expired 3 days earlier, electrical outlets that supposedly weren't up to current code despite passing inspection 6 months prior. Brooke documented everything. She photographed inspectors, recorded conversations where legally permissible, and maintained detailed logs of each interaction. The federal agents monitoring her activities were impressed by her thoroughness and concerned by the escalating harassment. Shaw Morrison's approach was more direct. He began appearing at Brooke's salon regularly, always with a reason that sounded legitimate but felt like intimidation. He needed directions to the courthouse. He was looking for a business lunch recommendation. He wondered if Brooke knew anything about property values in the neighborhood. During his 3rd visit, Shaw made his intentions clear. Ms. Washington, you know, this neighborhood is changing. Property values, development opportunities. Smart business owners are getting out ahead of the curve. Brooke continued cutting Mrs. Cross's hair without looking up. Getting out how? Selling to developers who understand the area's potential. Taking fair market value for properties before circumstances change. What kind of circumstances? Shaw's smile was cold, calculated. Code enforcement, zoning changes. Sometimes businesses find that operating costs become prohibitive. Mrs. Cross shifted uncomfortably in her chair. Brooke's scissors never paused, but her eyes met Shaw's in the mirror. Mr. Morrison, are you suggesting that business operations might become difficult for owners who don't sell? I'm suggesting that smart business owners recognize opportunity. And owners who don't recognize opportunity? Shaw adjusted his tie. Well, sometimes circumstances force recognition. After Shaw left, Brooke immediately called Agent Patterson. The conversation had been recorded by devices installed throughout the salon, and Shaw Morrison had just provided federal prosecutors with evidence of criminal extortion under the Hobbs Act. But Shaw Morrison wasn't the only one escalating pressure. Judge Holloway began scheduling emergency hearings for Brooke's case at unusual times. 8 a.m. on Saturday, 6 p.m. on Friday evening, noon on Wednesday with 24 hours notice. Each hearing required Brooke to close her salon, losing income and frustrating customers. During one such hearings, Holloway made his contempt explicit. Ms. Washington, you seem to enjoy disrupting this court's schedule with frivolous motions and irrelevant legal citations. Brooke had filed a motion requesting discovery materials, standard procedure in any criminal case. Your Honor, I'm simply requesting evidence that will be used against me at trial. You're requesting materials you couldn't possibly understand. You're not an attorney. No, Your Honor, but I have the right to review evidence regardless of my educational background. Holloway's face reddened. You have the right to sit quietly while qualified people handle legal matters. You're a beautician, not a lawyer. Your Honor, my profession doesn't affect my constitutional rights. Your constitutional rights? Holloway's laugh was theatrical, performed for the gallery where Shaw Morrison sat taking notes. You think you understand constitutional rights? You think cutting hair qualifies you to interpret law? Brooke remained standing, her voice calm and respectful. Your Honor, I think the Constitution applies equally to all citizens. All citizens, you think you're the same as everyone else in this courtroom? You think your little ghetto business makes you equal to people who actually contribute to this community? Agent Patterson, sitting in the gallery disguised as a reporter, documented every word. Judge Holloway was providing federal prosecutors with evidence of judicial bias based on racial and socioeconomic discrimination. Brooks' response was measured, deliberate. Your Honor, I think justice should be equal. Justice. Holloway stood leaning forward over his bench. You want to talk about justice? You're a drug dealer hiding behind hair products. You're nothing but ghetto trash pretending to be respectable. The courtroom fell silent. Shaw Morrison smiled. Devin Holloway nodded approvingly. Brooke reached into her purse. Your Honor, I have a question about yesterday's conversation. Holloway froze. Brooke withdrew her phone, finger hovering over an audio file marked with the previous day's date and timestamp. The conversation where you told Mr. Morrison that my prosecution needed to be expedited before the election. Judge Holloway's gavel clattered to his bench. Shaw Morrison stood abruptly and headed for the exit. Agent Patterson subtly photographed everyone's reactions. Brooke looked up from her phone, meeting Judge Holloway's terrified gaze. Would you like me to play that recording for the court? The silence stretched until Holloway found his voice. This court is in recess. Permanent recess. Case dismissed. But Brooke wasn't finished. Your Honor, I believe federal authorities might be interested in reviewing these recordings. Judge Holloway's face went white. Shaw Morrison had reached the courtroom doors but stopped, turning back with obvious dread. Brooke smiled politely. After all, equal justice requires equal accountability. The lock clicks twice. Then silence. Hold up. Did you catch what just happened? Because if you blinked, you missed the clue that's about to expose everything. This is why I love telling these stories, and why you should subscribe right now. Brooke's about to pull out evidence that even I didn't see coming. The next 5 minutes will leave you speechless. Agent Patterson approached Brooke in the courthouse parking lot 20 minutes later, his face grim with professional concern and personal admiration. Ms. Washington, what you just did in there was incredibly brave and incredibly dangerous. Brooke locked her car and faced him directly. Agent Patterson, what I just did was document federal crimes in real time. Judge Holloway and Shaw Morrison just provided you with enough evidence for conspiracy charges, civil rights violations, and obstruction of justice. They also just declared war on you personally. Brooke's smile was cold, determined. Good. People make more mistakes when they're angry. That evening, Brooke sat in her apartment reviewing the day's events while Agent Patterson and his team analyzed recordings that would form the foundation of federal indictments. Her phone rang at 10:43 p.m. Unknown number. Ms. Washington, you don't know me, but I think we should meet. I have information about Judge Holloway that you need to hear. Brooke activated the call recording app Agent Patterson had installed on her phone. Who is this? Someone who's been waiting 8 years for the right person to expose what's really happening in Franklin County. The caller's voice was female, nervous but determined. My name is Detective Lisa Warren. I'm Officer Blake's partner, and I think you're the person who can finally bring down this whole operation. As Brooke listened to Detective Warren explain a corruption network that extended far beyond anything she'd imagined, she realized her confrontation with Judge Holloway had been just the beginning. The real fight was about to start. Detective Lisa Warren met Brooke at a 24-hour diner on the outskirts of Franklin County at 11:30 p.m. The location was deliberate, far enough from downtown to avoid casual observation, late enough that most of Franklin County's 8,000 residents were asleep. Warren arrived first, choosing a corner booth with clear sightlines to both entrances. When Brooke entered, Warren recognized her immediately despite never having met. The woman who'd turned Judge Holloway's courtroom upside down looked smaller in person, more ordinary. But her eyes held the same sharp intelligence that had unnerved courthouse employees for months. Ms. Washington, I'm Lisa Warren. The detective stood, extending her hand. Mid-30s, blonde hair pulled back severely, wearing jeans and a Franklin County Sheriff's Department sweatshirt that had seen better days. Thank you for coming. Brooke slid into the booth, noting Warren's positioning. Back to the wall, clear view of exits, hands visible but ready. Police training, but also someone who'd learned to be careful. Detective Warren, your call mentioned information about Judge Holloway. What kind of information? Warren opened a manila folder revealing photographs that made Brooke's blood run cold. Shaw Morrison entering Judge Holloway's private chambers after hours. Stacks of cash being transferred between briefcases in courthouse parking lots. Time-stamped images of city officials meeting at Morrison's development office during city council sessions. I've been documenting corruption in Franklin County for 18 months, Warren said quietly. Taking photos, recording conversations, building a case file that nobody wanted to see. Brooke studied the photographs with the analytical precision Agent Patterson had noted. Why didn't you take this to Internal Affairs, the state attorney's office? Warren's laugh was bitter. Internal Affairs reports to Sheriff Hayes, who plays golf with Shaw Morrison every Thursday. State Attorney Rebecca Mills received campaign contributions totaling $47,000 from Morrison Development last election cycle. So you've been working alone. Until now. Warren leaned forward, lowering her voice. What you did in that courtroom today changed everything. For 8 years, people like Morrison and Holloway operated with impunity because nobody had the knowledge, the evidence, and the courage to challenge them publicly. Brooke sipped the coffee Warren had ordered for her. Black, no sugar, exactly how she preferred it. You've been watching me. I've been watching everyone. It's what good detectives do. Warren opened another folder. This one containing detailed surveillance logs. Your salon serves 63% of Franklin County's municipal employees. Court staff, police officers, city workers, county commissioners. You've had access to information that took me 18 months to piece together. Access isn't the same as understanding. Warren smiled for the first time since Brooke had arrived. Ms. Washington, you cited Florida Evidence Code Section 90.951 in open court. You referenced Fourth Amendment jurisprudence during a bond hearing. You've documented municipal code violations with legal precision. Don't pretend you're just a hairdresser who listens well. Brooke was quiet for a long moment, weighing how much truth she could afford to share. Detective Warren represented an opportunity, another law enforcement professional who'd seen the system's failures and decided to act. But she also represented risk. Brooke's cooperation with federal authorities was supposed to remain confidential. Detective Warren, what exactly are you asking me to do? I'm asking you to help me finish what you started today. Judge Holloway and Shaw Morrison are panicking. Panicked people make mistakes. I want to be in position to document those mistakes when they happen. Warren spread additional photographs across the table. Emergency meetings at Morrison's development office. Judge Holloway's Cadillac parked at unusual locations. City officials who'd normally avoid each other suddenly spending time together. These photos were taken in the 6 hours since your court appearance today. They're coordinating damage control, but they don't know how much evidence you actually have. Brooke studied the images with growing understanding. They think the recording I mentioned is just the beginning. Is it? Brooke met Warren's eyes directly. Detective, if I answer that question, I need to know you're committed to seeing this through, regardless of consequences. Ms. Washington, I've been collecting evidence of corruption for 18 months while watching innocent people lose their homes, their businesses, their livelihoods. I'm committed. Brooke pulled out her phone, scrolled through dozens of audio files, and placed it on the table between them. I have 43 hours of recorded conversations between city officials, courthouse staff, and private citizens. Everything from municipal code violations to federal civil rights law. Everything documented with timestamps, locations, and corroborating evidence. Warren stared at the phone. Holy cow! How did you record all this without anyone knowing? Customers talk while getting their hair cut. They forget stylists have ears. After 8 months of listening to descriptions of systematic harassment, I started documenting everything. Brooke opened her purse and retrieved a small recording device no larger than a USB drive. Hair salons are perfect surveillance locations. People relax. They gossip. They complain about work. Warren examined the device with professional interest. This is sophisticated equipment. Federal agents provided it 3 days ago, along with legal authorization for recording in public spaces and one-party consent situations. The detective's eyes widened. Federal agents? Brooke nodded. FBI Civil Rights Division. Agent Robert Patterson and Agent Rachel Brooks. They've been investigating Franklin County for 8 months based on complaints about systematic discrimination. And you're cooperating with them? I'm documenting criminal activity that affects my community. The federal government happens to be interested in the same criminal activity. Warren leaned back, processing the implications. Ms. Washington, if the FBI is already involved, why do you need local law enforcement cooperation? Because federal investigations take time. Years, sometimes. People in my community are losing their homes and businesses now. They need local action to complement federal oversight. Warren nodded slowly. What kind of local action? Brooke opened another folder, one Warren hadn't noticed her carrying. Inside were copies of formal complaints, evidence documentation, and legal motions prepared with professional precision. I'm filing misconduct complaints against Judge Holloway with the Florida Judicial Qualifications Commission, civil rights violation reports with the State Attorney General's Office, municipal code enforcement complaints with county commissioners, Every document supported by recorded evidence and witness statements. That's comprehensive. Detective Warren, systematic corruption requires systematic response. You can't fix conspiracy with individual actions. Warren spent 20 minutes reviewing Brooks' documentation while asking increasingly detailed questions about evidence collection, legal procedure, and federal coordination. Her respect for Brooks' preparation grew with each answer. Ms. Washington, I want to help, but I need to understand the risks. If Morrison and Holloway discover our cooperation, what kind of retaliation should I expect? Brooks' expression sobered. Professional retaliation, certainly. Transfer to undesirable assignments, negative performance evaluations, pressure to resign. Possibly criminal charges if they can manufacture evidence. Personal retaliation? More dangerous. Morrison has connections to people who solve problems through intimidation. Slashed tires, broken windows, anonymous threats. Maybe worse if they feel cornered. Warren was quiet for several minutes, considering options and consequences. Finally, she reached across the table and shook Brooks' hand. When do we start? Brooks' story shows how important it is to understand your rights. That's where Masterclass comes in. Learn from legal experts, civil rights leaders, and investigative journalists who break down complex topics into actionable knowledge. Whether it's constitutional law with David Axelrod or investigative techniques with Bob Woodward, Masterclass gives you the tools to protect yourself and your community. Get unlimited access to every class with an annual membership. Visit masterclass.com and Justice for 15% off, because knowledge is the ultimate protection. The following morning, Brooke arrived at Washington Curls & Company to find Agent Patterson waiting in his unmarked sedan. His presence at 7 a.m. suggested developments that couldn't wait for normal business hours. Ms. Washington, we need to talk privately. Brooke unlocked the salon and gestured for Patterson to enter. The space felt different now. No longer just a neighborhood business, but the center of a federal investigation that was expanding rapidly. Agent Patterson, what's happened? We've been monitoring communications between Judge Holloway and Shaw Morrison since your court appearance yesterday. They're planning something significant. Patterson opened his laptop and played an audio file recorded through federal wiretaps. Shaw Morrison's voice, strained and angry. This has to end, Bernard. She knows too much, and she's not backing down like we expected. Judge Holloway's response was equally tense. What are you suggesting? I'm suggesting we accelerate the timeline. Get her out of the picture before she can cause more damage. How do you propose we do that? Leave that to me. You just make sure the legal end stays clean. The recording ended. Patterson studied Brooks' face, looking for signs of fear that weren't there. Ms. Washington, do you understand what they're discussing? They're planning to escalate harassment until I close the salon and leave Franklin County. Brooke poured coffee with steady hands. Physical intimidation, probably. Property damage. Maybe personal threats. You don't seem concerned. Brooke smiled. Agent Patterson, I've been expecting escalation since the day I first documented their activities. People like Morrison and Holloway don't surrender power voluntarily. What they're discussing could be dangerous. What they're discussing is additional evidence of conspiracy and civil rights violations. The more desperate they become, the more mistakes they make. Patterson closed his laptop. Ms. Washington, we're prepared to offer you federal witness protection if you feel unsafe continuing normal operations. I appreciate the offer, but witness protection means hiding. Hiding means they win. Brooke opened her appointment book, noting the day's schedule. Mrs. Cross at 8:30, 3 regulars between 10 and noon. Court reporter Jade Mills at 2 p.m. Jade Mills is still coming for appointments? Even after yesterday's court hearing? Especially after yesterday's court hearing. Jade has information about Judge Holloway's instructions to alter official court transcripts. She's been waiting for someone she could trust with evidence that could end her career if it became public. Patterson leaned forward. What kind of evidence? Audio recordings of judicial instructions to modify official records. Written directives to summarize rather than quote verbatim during sensitive proceedings. Documentation of pressure to exclude certain testimony from formal transcripts. That's obstruction of justice. Among other charges. Brooke opened a secure file on her laptop. Agent Patterson, would you like to review evidence collected from courthouse employees over the past 8 months? For the next 2 hours, Brooke walked Patterson through a comprehensive intelligence network that had operated under everyone's noses for nearly a year. Hair salon appointments had become informal debriefing sessions where stressed courthouse employees shared frustrations about irregular procedures, judicial pressure, and municipal corruption. Officer Blake had described pressure to target minority-owned businesses during routine patrols. Court clerks had mentioned unusual scheduling patterns that favored certain attorneys and developers. City planning employees had discussed anonymous complaints that consistently affected the same neighborhood properties. Ms. Washington, this intelligence gathering operation is more sophisticated than most law enforcement investigations. It's not an operation, Agent Patterson. It's community members sharing their experiences with someone who listened and remembered. Patterson reviewed pages of meticulous documentation. Dates, times, personnel involved, specific procedures violated. How did you know which details were legally significant? Brooke gestured toward bookshelves lined with legal texts. I've been studying law for 8 years. Municipal codes, civil rights statutes, criminal procedures. When your customers work in the justice system, you learn how justice is supposed to work. And when you see it working differently, you start taking notes. At 8:30 a.m., Mrs. Cross arrived for her regular appointment, accompanied by an elderly gentleman Brooke didn't recognize. 70-something, well-dressed, carrying a briefcase that suggested professional rather than personal business. Brooke, dear, this is Judge William Garrett, retired from State Appellate Court. He's been following your situation. Judge Garrett extended his hand with formal courtesy. Ms. Washington, I've heard remarkable things about your legal knowledge and evidence documentation. I'd like to offer assistance if you're interested. Brooke studied the retired judge carefully. What kind of assistance? Legal representation. Pro bono, of course. You're facing charges that require experienced counsel, and you're challenging corruption that demands constitutional expertise. Agent Patterson shifted in his chair, clearly uncomfortable with unexpected developments in what was supposed to be a controlled federal operation. Judge Garrett, I appreciate the offer, but my situation is complicated by ongoing federal cooperation. Garrett's expression remained neutral, professional. Ms. Washington, federal cooperation and vigorous legal defense aren't mutually exclusive. In fact, competent representation often enhances federal cases by ensuring constitutional procedures are followed. What's your interest in this case? I've been watching Franklin County's judicial irregularities for 5 years. Judge Holloway's behavior has deteriorated steadily, but complaints to appropriate authorities have been ignored or redirected. Your public challenge represents the first real accountability he's faced. Mrs. Cross settled into Brooke's styling chair while listening to the conversation with obvious approval. Child, you need someone who understands the law on your side. Judge Garrett helped my grandson with college applications after his scholarship got mysteriously revoked. He knows how this system works. Agent Patterson cleared his throat. Judge Garrett, federal investigations require careful coordination. Additional legal representation could complicate ongoing operations. Garrett's smile was polite but firm. Agent Patterson, constitutional rights don't pause for federal convenience. Ms. Washington has the right to competent counsel regardless of her cooperation status. Brooke considered the offer while working conditioner through Mrs. Cross's hair. Legal representation would provide protection against procedural manipulation, but it might also limit her flexibility in federal cooperation. Judge Garrett, what would pro bono representation involve? Complete legal defense against current charges, plus civil rights litigation against Franklin County for systematic discrimination. We'd coordinate with federal authorities, but maintain independent advocacy for your interests. And if federal cooperation conflicts with legal defense, constitutional rights take precedence. Always. Agent Patterson looked increasingly uncomfortable. Ms. Washington, this decision could affect federal protection and evidence admissibility. Brooke met Patterson's eyes directly. Agent Patterson, my cooperation with federal authorities is voluntary. It remains voluntary regardless of legal representation. She turned to Judge Garrett. I accept your offer. The next 3 hours transformed Brooke's salon into an impromptu legal strategy center. Judge Garrett reviewed evidence files with professional thoroughness while Agent Patterson coordinated federal surveillance updates. Mrs. Cross provided community intelligence about neighborhood reaction to recent events. By noon, a comprehensive legal and investigative plan had emerged. Judge Garrett would file federal civil rights litigation against Franklin County while defending Brooke against criminal charges. Agent Patterson would coordinate federal evidence collection with local legal proceedings. Brooke would continue community intelligence gathering while maintaining federal cooperation. Officer Blake arrived at 12:30 for what appeared to be a routine haircut but was actually an intelligence briefing. His information about increased pressure from department leadership confirmed Agent Patterson's surveillance findings. They're calling it enhanced compliance enforcement, Blake explained while Brooke trimmed his hair. Mandatory overtime for business district patrols. Immediate reporting requirements for any contact with Washington Curls and Company. Written justification needed for any interaction with you. Brooke noted the information while maintaining casual conversation. Sounds like micromanagement. Sounds like they're trying to isolate you from any police contact, create documentation suggesting you're uncooperative or threatening. Agent Patterson, positioned where he could monitor the conversation, recorded every detail for federal evidence files. Officer Blake, are other officers experiencing similar pressure? Anyone who's had normal interactions with minority business owners. They're reviewing patrol logs going back 6 months, looking for patterns of inappropriate community engagement. Judge Garrett looked up from legal documents he was reviewing. Officer Blake, would you be willing to provide sworn testimony about departmental pressure to avoid contact with specific citizens based on race or civil rights activity? Blake considered the question seriously. Judge, that testimony would probably end my career with Franklin County Sheriff's Department. It might, but it would also help end systematic corruption that's already damaging your community and your profession. Give me 24 hours to think about it. As Blake left, Brooke realized the scope of retaliation was expanding beyond anything she'd anticipated. Morrison and Holloway weren't just targeting her business. They were attempting to isolate her from any community support or professional assistance. Court reporter Jade Mills arrived at 2 p.m. carrying a briefcase that suggested she'd made her own decision about cooperation versus career protection. 28 years old, nervous but determined, she'd obviously spent considerable time preparing for this conversation. Brooke, I need to tell you things about Judge Holloway that could get me fired, but after what I saw yesterday, I can't stay quiet anymore. Jade opened her briefcase and removed a digital recorder, laptop computer, and manila folder thick with printed documents. I've been keeping personal copies of court proceedings that Judge Holloway ordered modified or excluded from official records. 18 months of documented instructions to alter transcripts, summarize rather than quote, and exclude specific testimony from formal documentation. Agent Patterson leaned forward with obvious interest. What kind of alterations? Judicial statements showing bias, attorney objections that were sustained but later changed to overruled in official records, witness testimony that contradicted prosecution theories, settlement discussions that happened on the record but disappeared from transcripts. Judge Garrett examined sample documents while Jade explained the systematic nature of transcript manipulation. Judge Holloway would call me into chambers after proceedings and provide specific instructions about what to include, exclude, or modify in official records. He said it was for clarity and legal precision, but the changes consistently favored prosecution cases and development interests. Did you document these instructions? Jade opened her laptop and played an audio file recorded during one such meeting. Judge Holloway's voice. Jade, the defendant's constitutional arguments in today's hearing were irrelevant to case disposition. Summarize them briefly rather than quoting extensively. Jade's voice. Your Honor, standard procedure requires verbatim recording of all constitutional issues raised by either party. Judge Holloway. Standard procedure is whatever I determine necessary for efficient court operations. Your job is to follow instructions, not interpret legal requirements. The recording continued for 12 minutes, documenting multiple instances of judicial pressure to violate court reporting professional standards. How many recordings do you have? 47 separate conversations over 18 months, plus written directives, email instructions, and documented pressure to modify official records. Agent Patterson was taking detailed notes. Ms. Mills, these recordings represent evidence of systematic obstruction of justice and judicial misconduct. Are you prepared to testify in federal proceedings? I'm prepared to do whatever's necessary to restore integrity to Franklin County's court system. The afternoon brought a steady stream of customers who seemed less interested in hair services than in sharing information about unusual activities throughout Franklin County. Sandra from the tax office mentioned pressure to reassess minority-owned properties for increased taxation. Mark from the post office described mail delivery delays affecting specific addresses. Lisa from the court clerk's office reported unusual scheduling pressure and document handling irregularities. By 5 p.m., Brooke had compiled intelligence indicating that Morrison and Holloway's corruption network extended far beyond real estate development and judicial bias. They'd created a comprehensive system of municipal harassment designed to force minority business owners to sell properties below market value. Agent Patterson, we're not dealing with isolated corruption. This is systematic suppression of an entire community. Patterson reviewed the day's evidence collection with growing amazement. Ms. Washington, you've documented a civil rights conspiracy involving municipal government, law enforcement, and judicial administration. This is federal prosecution material under multiple statutes. Judge Garrett closed his laptop after hours of legal research. This is also grounds for comprehensive civil rights litigation that could result in federal oversight of Franklin County government operations. Brooke looked around her salon, the place where she'd built a business, served her community, and accidentally discovered systematic corruption that reached every level of local government. When do we file charges? The next morning brought news that Shaw Morrison had filed an emergency injunction seeking to prevent Brooke from operating her business pending resolution of criminal charges. The legal maneuver was transparently retaliatory, but it forced an immediate court hearing that would bring all parties together for the first time since Brooke's dramatic courtroom revelation. Judge William Garrett arrived at Brooke's apartment at 6 a.m. with legal documents, strategy notes, and coffee strong enough to fuel a Supreme Court argument. Brooke, Morrison's injunction is procedurally invalid, substantively groundless, and obviously retaliatory. But Judge Holloway has scheduled an emergency hearing for 9 a.m. today. How can Holloway preside over proceedings involving his own misconduct? He can't, legally, which means he's either ignorant of recusal requirements or desperate enough to ignore them. Garrett opened his briefcase and retrieved motions prepared overnight. We're filing immediate recusal demands based on documented bias, personal interest in case outcome, and judicial misconduct. Brooke reviewed Garrett's legal work with growing appreciation for his thoroughness. Motion for recusal. Motion to dismiss injunction as retaliatory. Motion for contempt of court based on previous judicial statements. Motion for immediate federal intervention. Judge Garrett, these motions will essentially declare war on Franklin County's entire judicial system. Brooke, Franklin County's judicial system declared war on constitutional rights months ago. We're simply responding with appropriate legal force. Agent Patterson arrived 30 minutes later with updates on federal surveillance and evidence collection. Morrison and Holloway held an emergency meeting at 6 a.m. this morning. They're planning to use today's hearing to force you into accepting a plea agreement or face immediate business closure. What kind of plea agreement? Guilty plea to reduced charges in exchange for leaving Franklin County permanently. They want you gone more than they want criminal conviction. Brooke considered the implications. And if I refuse? They escalate harassment until you're forced to close anyway. Property condemnation, business license revocation, personal safety threats. Judge Garrett looked up from legal documents. Agent Patterson, are federal authorities prepared to intervene if local proceedings violate constitutional protections? We're prepared to take action if systematic civil rights violations continue or escalate. That's not a direct answer. Patterson met Garrett's eyes steadily. Judge, federal intervention in local judicial proceedings requires compelling evidence of constitutional violations that can't be addressed through normal appellate processes. And you believe today's hearing will provide that evidence? I believe Judge Holloway and Shaw Morrison are desperate enough to make mistakes that will justify federal intervention. At 8:30 a.m., Brooke, Judge Garrett, and Agent Patterson arrived at Franklin County Courthouse to find media vehicles and federal agents positioned strategically throughout the building. Word of the hearing had spread through professional networks, attracting attention from civil rights organizations, legal advocacy groups, and journalists who specialized in small-town corruption stories. Shaw Morrison waited in the courthouse lobby with 3 attorneys, a public relations consultant, and what appeared to be private security personnel. His usual confident demeanor had been replaced by barely controlled anxiety. Judge Holloway's chambers were closed to visitors, but courthouse employees reported unusual activity. Emergency consultations with court administration, lengthy phone calls with state judicial authorities, and obvious preparations for proceedings that might attract scrutiny beyond Franklin County. The courtroom filled rapidly with an unusual mix of spectators, federal agents, civil rights observers, community members, and media representatives. The gallery buzzed with whispered conversations about evidence, misconduct allegations, and possible federal intervention. At 9 a.m. sharp, Judge Holloway entered his courtroom with visible reluctance. His usual theatrical confidence had been replaced by defensive positioning that suggested awareness of career-ending scrutiny. This court is now in session. We're here for emergency proceedings in the matter of Shaw Morrison versus Brooke Washington, case number 2024-1158. Judge Garrett rose immediately. Your Honor, before any proceedings begin, I'm filing multiple motions on behalf of Ms. Washington. Mr. Garrett, this is an emergency hearing. There's no time for frivolous motions. Your Honor, these motions address fundamental due process violations and judicial misconduct that affect this court's jurisdiction to hear any matters involving my client. Holloway's face reddened. Mr. Garrett, you're out of order. Sit down. Garrett remained standing. Your Honor, I'm filing a motion for your immediate recusal based on documented bias, personal interest in case outcome, and public statements demonstrating prejudice against my client. Motion denied without consideration. Your Honor, you can't deny a recusal motion without reviewing supporting evidence. Florida Code of Judicial Conduct requires consideration of bias allegations. Holloway gripped his gavel like a weapon. Mr. Garrett, I've warned you about frivolous disruptions. Agent Patterson, sitting in the gallery with recording equipment clearly visible, documented every exchange for federal evidence files. Shaw Morrison's lead attorney, a 60-something corporate lawyer named Harrison Wells, stood to address the court. Your Honor, we're seeking emergency injunctive relief to prevent continued operation of Washington Curls and Company pending resolution of serious criminal charges against the defendant. Judge Garrett immediately objected. Your Honor, criminal charges don't justify civil injunctions unless plaintiff demonstrates irreparable harm that can't be addressed through normal judicial processes. Mr. Wells, Judge Holloway said, ignoring Garrett's objection, please continue. Your Honor, the defendant operates a business that presents ongoing threats to community safety and business integrity. Her recent courtroom behavior demonstrates disrespect for legal authority and unwillingness to cooperate with judicial proceedings. Brooke listened to Morrison's lawyer describe her as a community threat while documenting every statement for potential defamation action. The irony was overwhelming. Men who'd systematically violated civil rights were portraying her as a danger to community welfare. Judge Garrett rose again. Your Honor, I object to unsubstantiated characterizations of my client. Mr. Wells has provided no evidence of community threats or safety concerns. Objection overruled. Mr. Wells, do you have evidence supporting emergency relief? Wells opened a file and began reading allegations that seemed carefully crafted to justify business closure without admitting systematic harassment. Your Honor, the defendant has engaged in secretly recording private conversations, conducting unauthorized surveillance of city officials, and making public accusations against respected community leaders without substantiation. Those are lies, Mrs. Cross called out from the gallery. Judge Holloway banged his gavel. Order! I'll have order in this courtroom. But Mrs. Cross remained standing, her 72-year-old frame radiating righteous anger. Your Honor, that man is lying about Brooke Washington and everyone in this room knows it. Ma'am, sit down immediately or face contempt charges. I'll sit down when you stop letting that developer destroy our community. Agent Patterson noted the exchange while photographing courtroom dynamics that demonstrated community support for Brooke despite systematic intimidation efforts. Judge Garrett seized the moment. Your Honor, community reaction demonstrates that emergency injunctive relief lacks public support and serves private interests rather than public welfare. Mr. Garrett, community opinion is irrelevant to legal proceedings. Your Honor, community opinion is highly relevant to constitutional analysis of government action that affects civil rights. Shaw Morrison stood abruptly from his seat in the gallery. Your Honor, this is exactly the kind of disruption we're trying to prevent. She's turned normal business operations into community activism. Judge Garrett turned toward Morrison with obvious satisfaction. Your Honor, Mr. Morrison just admitted that this injunction is intended to suppress community activism, which would violate First Amendment protections. Holloway realized too late that Morrison's outburst had provided legal ammunition for constitutional challenges. Mr. Morrison, please remain silent during proceedings. But Morrison was beyond careful restraint. Judge, we discussed this. She needs to be stopped before federal attention gets out of hand. The courtroom fell dead silent. Shaw Morrison had just admitted to ex parte communications with Judge Holloway about case strategy, a clear violation of judicial ethics that required immediate recusal. Judge Garrett spoke quietly, but his words carried to every corner of the courtroom. Your Honor, Mr. Morrison's statement constitutes admission of improper ex parte communication about pending litigation. This court must recuse itself immediately. Judge Holloway's gavel clattered to his bench. Shaw Morrison's face went white as he realized his mistake. Agent Patterson photographed everything while calling for federal backup. Brooke stood slowly, her purse in her hand, phone screen visible to everyone in the courtroom. Your Honor, would you like me to play the recording of yesterday's conversation where Mr. Morrison discussed federal attention getting out of hand? The silence stretched until Holloway found his voice, strained and desperate. This court stands in recess pending consultation with appropriate authorities. But Brooke wasn't finished. She touched her phone screen, and Shaw Morrison's voice filled the courtroom through the salon's Bluetooth speakers she'd connected that morning. Bernard, federal agents are asking questions. We need to expedite her removal before they find evidence we can't explain. Judge Holloway's voice responded clearly. How much time do we have? Morrison. Depends how much she actually knows. If she has recordings of city council meetings, planning commission sessions, our courthouse conversations, Holloway. She's a hairdresser, Shaw. How much could she possibly know? Morrison. Enough to destroy both of us if federal authorities take her seriously. The recording continued for another 30 seconds before Brooke touched her screen again, ending playback. The courtroom erupted in whispers, gasps, and furious note-taking by media representatives. Agent Patterson was already on his phone, coordinating immediate federal response to documented obstruction of justice. Judge Garrett stood calmly in the chaos. Your Honor, I move for immediate dismissal of all proceedings, recusal of this court, and referral to federal authorities for civil rights investigation. Shaw Morrison was gathering his papers frantically while his attorneys huddled in obvious panic. Judge Holloway sat frozen behind his bench, career and freedom evaporating in real time. Brooke looked around the courtroom filled with federal agents, media representatives, and community members who'd watched systematic corruption finally face accountability. Your Honor, I have a question about the timeline we just heard. Holloway couldn't speak. Morrison was heading for the exit. Brooke continued, her voice carrying clearly through the silent courtroom. The conversation about federal attention was recorded at 3:47 p.m. yesterday. But federal agents first contacted me 6 days ago, which means you've known about federal investigation for nearly a week. Agent Patterson stood and approached the bench with federal credentials clearly visible. Judge Holloway, Shaw Morrison, you're both under arrest for conspiracy to violate civil rights, obstruction of justice, and corrupt interference with federal investigation. The big reveal. As Agent Patterson read Miranda rights to Judge Holloway and Shaw Morrison, Brooke realized this moment had been building since her first customer complained about banking discrimination 8 months ago. Every conversation, every observation, every carefully documented irregularity had led to this revelation of systematic corruption. Agent Rachel Brooks entered the courtroom with additional federal agents and arrest warrants for Devin Holloway, Inspector Kane, and 3 other city officials. The scope of the investigation extended far beyond anything Franklin County had imagined. Ladies and gentlemen, Agent Brooks announced, the Federal Bureau of Investigation has concluded an 8-month investigation into civil rights violations, municipal corruption, and judicial misconduct in Franklin County. We're executing multiple arrest warrants today. Judge Garrett approached the bench where Judge Holloway sat in handcuffs, no longer the powerful figure who'd terrorized defendants for years. William, Garrett said quietly, using Holloway's first name to emphasize their shared profession, you had an opportunity to serve justice. Instead, you chose to serve private interests. The legal profession will survive your disgrace, but it will take time to repair the damage you've caused. Shaw Morrison, also handcuffed and surrounded by federal agents, stared at Brooke with undisguised hatred. You have no idea what you've done. This community depends on development investment. You've destroyed economic growth for your personal vindication. Brooke met his gaze steadily. Mr. Morrison, economic growth built on systematic oppression isn't growth. It's exploitation. Agent Patterson concluded Miranda warnings and began escorting arrestees from the courtroom while media representatives documented every moment of what would become national news within hours. Mrs. Cross approached Brooke as federal agents cleared the courtroom. Child, I've lived in Franklin County for 72 years. I've seen segregation, integration, and everything since. But I've never seen one person stand up to systematic corruption and win. Brooke hugged the elderly woman who'd provided moral support throughout months of escalating pressure. Mrs. Cross, I didn't win. We won. Everyone who shared information, provided support, took risks to expose the truth. Judge Garrett began collecting legal documents while coordinating with federal prosecutors about next steps in comprehensive civil rights litigation. Brooke, this is just the beginning. Criminal prosecutions will take months or years. Civil rights cases will take longer. Systematic change requires sustained effort. I understand. Agent Patterson returned to brief Brooke on immediate developments. Ms. Washington, we're executing search warrants at Shaw Morrison's development office, Judge Holloway's private chambers, city planning department, and 6 other locations. The investigation scope is expanding based on evidence collected over the past 8 months. How long will prosecutions take? Federal criminal cases typically require 18 months to 2 years. Civil rights litigation can take much longer, but we have enough evidence for immediate charges against 12 individuals and 3 municipal departments. Brooke looked around the courtroom that had witnessed systematic corruption finally face accountability. Agent Patterson, what happens to the community while prosecutions proceed? Federal oversight of municipal operations until constitutional compliance is restored. Independent monitoring of police practices, judicial administration, and civil rights enforcement. Essentially, Franklin County government operates under federal supervision until we're confident systematic violations have ended. The media attention was immediate and intense. By noon, Brooks' confrontation with Judge Holloway had been viewed 2 million times on social media platforms. News organizations from across the country requested interviews with the hairdresser who'd brought down small-town corruption using nothing more than careful documentation and constitutional knowledge. Brooke declined most interview requests, preferring to let legal proceedings speak for themselves. But she did agree to speak with Jade Mills, who'd resigned from court reporting to pursue journalism covering civil rights and judicial accountability. "Brooke, you've become a symbol of individual resistance to systematic oppression. How does that feel?" "Uncomfortable," Brooke answered honestly. "I didn't set out to become a symbol. I set out to document problems affecting my community. But you must realize the broader significance of what you've accomplished." Brooke considered the question seriously. "Jade, what I've accomplished is providing evidence of crimes that were already happening. Federal agents, civil rights organizations, and legal advocates did the difficult work of building prosecutable cases and holding officials accountable. You're being modest. I'm being accurate. Individual action matters, but systematic change requires institutional response. What happened today is institutional response to documented constitutional violations. If Maya's story proved anything, it's that heroes come from the most unexpected places. But wait until you hear about the McDonald's worker who outsmarted a billion-dollar corporation using nothing but a receipt in her phone. Subscribe now because that story drops next week, and it's even more incredible than what you just witnessed. 6 months after Judge Holloway's arrest, Brooke stood in her salon reading federal court documents that would reshape Franklin County government for years to come. The comprehensive consent decree required municipal compliance with constitutional protections, independent oversight of civil rights enforcement, and federal monitoring of judicial administration. Judge Holloway had pleaded guilty to civil rights violations and obstruction of justice, receiving 18 months in federal prison and permanent disbarment from legal practice. Shaw Morrison faced trial on additional charges including racketeering and conspiracy, with prosecutors seeking 5 years imprisonment and forfeiture of development properties obtained through corruption. But the most significant change wasn't criminal prosecutions. It was systematic reform of municipal operations under federal oversight. Agent Patterson visited monthly to review compliance with constitutional requirements and investigate ongoing complaints. His reports documented steady progress in eliminating discriminatory practices, though cultural change proceeded slowly. Brooke, municipal employees are still adjusting to federal oversight. Some resistance is expected, but we're seeing measurable improvement in civil rights compliance. What kind of resistance? Passive non-cooperation, delayed responses to citizen complaints, minimal compliance rather than enthusiastic reform. Patterson opened files documenting recent developments. But we've also seen positive changes. New policies prohibiting discriminatory enforcement, training requirements for all municipal employees, community oversight committees with real authority. Brooke reviewed compliance reports while cutting Mrs. Cross's hair. The elderly woman had become an informal community liaison with federal overseers, attending public meetings and providing citizen perspective on reform efforts. Change is happening, but it's slower than people hoped. Some folks expected immediate transformation after Holloway's arrest. Systematic problems require systematic solutions, Brooke replied. Federal oversight creates structure for long-term change, but cultural transformation takes years. The salon had become an informal community center where residents discussed ongoing reforms, shared experiences with federal oversight, and coordinated advocacy for continued civil rights enforcement. Officer Blake, now assigned to community policing duties under federal supervision, stopped by for regular consultations about improved police-community relations. Brooke, the department's implementing new protocols for business district patrols, community engagement rather than enforcement focus. But some officers resist the changes. What kind of resistance? Old-school attitudes about law enforcement priorities. Some guys think constitutional protections interfere with effective policing. Judge Garrett, now representing multiple clients in civil rights litigation against Franklin County, used the salon as an informal meeting space for community legal education. Brooke, federal oversight creates opportunities for systematic reform, but communities must stay engaged to ensure reforms actually improve daily life. How do communities stay engaged? Persistent attention to municipal operations, regular attendance at city council meetings, formal complaints when problems continue. Civil rights enforcement requires community participation. By winter, Brooks' salon served 93 customers regularly, nearly double the pre-investigation number. Word had spread throughout the region about constitutional knowledge, federal connections, and effective advocacy for civil rights protection. New customers included courthouse employees from neighboring counties, police officers seeking guidance on constitutional law enforcement, and municipal workers trying to understand federal compliance requirements. The expanded clientele brought information about similar corruption in adjacent jurisdictions, suggesting Franklin County's problems were part of broader regional patterns. Detective Lisa Warren, now assigned to Federal Task Force Operation, coordinated multi-county investigations based on intelligence developed through community networks. Brooke, your documentation model is being replicated in 6 other counties. Community members are systematically recording municipal interactions and reporting constitutional violations. Is federal response expanding? Gradually. Each documented pattern supports additional investigations, but resources are limited, so progress depends on community cooperation and evidence quality. Brooke had developed training materials for community documentation, teaching constitutional rights and evidence collection to groups throughout the region. Her weekend workshops attracted activists, business owners, and concerned citizens from urban and rural communities. People need to understand their rights and document violations systematically, Brooke explained to participants. Individual complaints get ignored. Documented patterns trigger federal attention. Spring brought news that Shaw Morrison had been convicted on 12 federal charges and sentenced to 4 years imprisonment plus forfeiture of properties worth $3.7 million. His development company collapsed under federal investigation, creating opportunities for community-controlled economic development. Judge William Garrett coordinated civil rights settlements that provided funding for minority business development, community legal services, and constitutional education programs. Brooke, these settlements create resources for long-term community empowerment, but resources must be used strategically to prevent future systematic oppression. What does strategic use mean? Legal education so people understand their rights, economic development that benefits community residents rather than outside investors, political engagement that holds officials accountable to constitutional requirements. Summer marked the first anniversary of Brooks' courtroom confrontation with Judge Holloway. Franklin County had experienced fundamental changes in municipal operations, though progress remained uneven across different departments and officials. Federal oversight continued with quarterly compliance reviews and annual assessments of constitutional protection effectiveness. Community engagement had increased significantly with regular citizen participation in government meetings and civil rights monitoring, but systematic change remained incomplete. Some municipal employees continued discriminatory practices through passive resistance to federal requirements. Economic development still favored outside investors over community interests. Political power structures had adjusted to federal oversight without embracing genuine reform. Agent Patterson's annual report concluded that constitutional compliance was improving, but cultural transformation required continued federal supervision. Ms. Washington, your case catalyzed important reforms, but eliminating systematic oppression requires generational effort. Federal oversight creates structure for change, but communities must sustain pressure for continued progress. Brooke reflected on 12 months of federal investigation, criminal prosecutions, civil rights litigation, and municipal reform while preparing for another day of serving customers who'd become community advocates. Her composition notebooks now documented federal compliance rather than constitutional violations. Her recording equipment captured community organizing sessions rather than corrupt conversations. Her legal knowledge served advocacy training rather than evidence collection. The salon's mission had evolved from documentation to education, from resistance to reconstruction, from individual action to community empowerment. Temporary resolution 2 years after Judge Holloway's arrest, federal oversight of Franklin County had achieved measurable progress in constitutional compliance, while revealing the complexity of systematic reform. Criminal prosecutions had concluded with convictions for 12 municipal officials and 3 private individuals. Civil rights settlements had provided $4.9 million for community development and legal services. Federal monitoring had documented improved police practices and judicial administration, but Brooke understood that progress remained fragile and incomplete. Municipal elections had brought new officials committed to constitutional governance, but economic pressures continued favoring development interests over community needs. Federal oversight had eliminated overt discrimination while subtle bias persisted in policy implementation. Community organizing had increased civic engagement significantly, Yet many residents remained skeptical that lasting change was possible. Legal education had improved citizens' understanding of constitutional rights, though systematic oppression had evolved rather than disappearing. Agent Patterson's final report recommended continued federal monitoring with reduced intensity, acknowledging both progress achieved and challenges remaining. Ms. Washington, Franklin County has made significant strides in constitutional compliance, but systematic change requires sustained community engagement long after federal oversight ends. Judge Garrett concluded civil rights litigation with settlements ensuring long-term funding for community legal services and constitutional education. Brooke, legal victories create opportunities for systematic change, but communities must use those opportunities strategically to prevent regression. Brooke's salon had become a regional model for community-based civil rights advocacy, with delegations visiting from municipalities across the Southeast to learn documentation techniques and federal cooperation strategies. Her training programs had expanded to include online courses, legal advocacy workshops, and community organizing seminars that reached thousands of participants annually. But Brooke remained focused on daily service to Franklin County residents who'd supported her throughout months of escalating pressure and uncertain outcomes. Mrs. Cross, now 74 and serving on the Federal Community Oversight Committee, represented continuity between past struggles and ongoing reform efforts. Child, change is happening, but it's not complete. Each generation must fight for constitutional rights because oppression adapts to new circumstances. Officer Blake, promoted to Community Liaison Coordinator, embodied institutional change that required individual commitment to constitutional principles. Brooke, federal oversight taught us proper procedures, but daily implementation depends on personal choices about serving community interests versus private power. Open Mysteries. On a quiet Tuesday afternoon in October, exactly 3 years after her arrest, Brooke found an unmarked envelope slipped under her salon's front door. Inside was a single page of text printed on plain white paper. Ms. Washington, your Franklin County investigation was impressive, but it only scratched the surface. The corruption network extends across state lines, involves federal officials, and connects to operations you haven't imagined. If you're interested in the full scope, check your email tonight. Come alone. A friend. Brooke photographed the note and immediately contacted Agent Patterson, now assigned to the FBI's Public Corruption Unit in Atlanta. Agent Patterson, I've received what appears to be contact from someone with information about expanded corruption networks. What kind of information? Multi-state operations involving federal officials. The note suggests Franklin County was part of something much larger. Patterson was quiet for several moments. Ms. Washington, federal investigations often reveal connections to broader networks, but pursuing those connections can be extremely dangerous. More dangerous than challenging local corruption? Much more dangerous. If there's truly a multi-state network with federal connections, the people involved have resources and influence that dwarf anything you faced in Franklin County. That evening, Brooke checked her email to find a message from an encrypted account containing attachments that made her hands tremble as she opened them. Photographs of Judge Holloway meeting with federal courthouse officials in 3 different states. Financial records showing Shaw Morrison's development company receiving funding from sources traced to offshore accounts. Communication logs indicating coordination between Franklin County officials and similar operations in 12 other jurisdictions. The final attachment was a video file showing a conference room meeting with participants Brooke didn't recognize discussing rural county operations and community resistance management, in language that suggested systematic suppression of civil rights across multiple states. Her phone rang as she finished reviewing the materials. Ms. Washington, this is Assistant U.S. Attorney Marcus Webb from the Justice Department's Civil Rights Division. We need to discuss the information you received tonight. How do you know about information I received? Because we've been tracking the network that sent it. Your Franklin County case was connected to operations we've been investigating for 4 years. Brooke looked out her apartment window to see a black sedan with federal government license plates parked across the street. Mr. Webb, what exactly are you asking me to do? We're asking if you're willing to help expose systematic corruption that affects minority communities across the entire Southeast. What you accomplished in Franklin County could be replicated in dozens of jurisdictions if you're willing to expand your documentation and federal cooperation. And if I'm not willing, then a network of municipal corruption continues operating with federal protection while communities like Franklin County remain vulnerable to systematic oppression. Brooke considered the implications while reviewing photographs and documents that revealed corruption far beyond anything she'd imagined in her small Florida town. Mr. Webb, I'll need legal representation, community protection, and federal guarantees about witness safety. All of that can be arranged. The question is whether you're prepared for investigation scope that could take years and affect your life in ways you haven't experienced. Looking around her apartment filled with legal texts, federal compliance documents, and community organizing materials, Brooke realized her confrontation with Judge Holloway had been preparation for challenges that would test everything she'd learned about constitutional rights, systematic resistance, and federal cooperation. Mr. Webb, when do we start? 3 weeks later, Brooke Washington closed her salon for what she told customers would be a temporary vacation while she attended advanced legal education seminars. In reality, she was beginning undercover work with the Federal Bureau of Investigation to document systematic civil rights violations across a network of 12 states where municipal corruption operated under federal protection. Her first assignment involved relocating to a small Georgia town where minority business owners were experiencing harassment patterns identical to those she'd documented in Franklin County. The black sedan that had monitored her apartment now provided federal protection as she established a new identity as a traveling hairdresser specializing in community engagement and customer consultation. Her composition notebooks would once again document constitutional violations, but this time as part of a federal investigation targeting corruption networks that stretched from local courthouses to Washington, D.C. The last entry in her Franklin County documentation files read, "Systematic oppression requires systematic resistance. Individual action catalyzes institutional response. Community empowerment depends on sustained engagement with constitutional principles. Justice delayed is not justice denied if communities maintain pressure for accountability." Mrs. Cross found the note when she arrived to water Brooke's salon plants during her temporary absence. Reading Brooke's final words to Franklin County, the 74-year-old community elder understood that some fights required sacrifice, and some people were called to battles larger than their own neighborhoods. She locked the salon carefully and walked home through downtown Franklin County, where federal oversight continued. Constitutional compliance progressed slowly, and systematic change remained a work in progress requiring generational commitment. Above the salon door, a small sign read, "Washington Curls and Company, serving community needs since 2016, temporarily closed for advanced education. Reopening when justice requires." Below that, in smaller text, "For community legal resources and constitutional education, contact the Franklin County Civil Rights Center, funded through federal civil rights settlements and community advocacy efforts." 6 months later, news reports from a small Georgia town described a traveling hairdresser who had documented systematic municipal corruption using constitutional knowledge and federal cooperation techniques developed in Franklin County, Florida. The network was expanding, but so was resistance. Justice wasn't finished with systematic oppression, and systematic oppression wasn't finished challenging justice. The real fight continued in communities across America where ordinary people faced extraordinary pressure to accept inequality as inevitable. But Brooke Washington had proven that documentation plus knowledge, plus federal cooperation plus community support could challenge systematic corruption successfully. The question was whether enough people were willing to take the risks necessary to expand that success beyond individual victories towards systematic transformation. The answer would determine whether constitutional rights remained theoretical promises or became lived reality for communities that had waited too long for equal justice under law. In Franklin County, Mrs. Cross tended Brooke's salon plants and waited for the day when justice would no longer require heroes to sacrifice safety for constitutional principles. That day hadn't arrived yet, but it seemed closer than before Brooke Washington had walked into Judge Holloway's courtroom with recorded evidence and constitutional conviction. Progress measured in months and years rather than moments, but progress nonetheless toward the promise that justice, though delayed, would not be denied to communities willing to document, resist, and cooperate their way toward constitutional compliance. The salon door remained locked, but the movement it had launched continued in communities across the country where systematic oppression faced increasingly systematic resistance. And somewhere in Georgia, a hairdresser with federal protection and constitutional knowledge was cutting hair, listening carefully, and taking notes that would challenge corruption wherever it thrived on the assumption that ordinary people couldn't understand their rights well enough to demand accountability. The assumption was proving wrong, one documented violation at a time.